Florida voters restored voting rights to ex-convicts last November, but now there's another hurdle for former inmates before they can exercise those voting rights. As Shelby Danielson explains, it's leading to backlash, including a lawsuit against the state.
Since Election Day, questions have lingered regarding the restoration of ex-felon voting rights, concerns from county supervisors over implementation, registration, and interpretation of Amendment 4. And now the controversial new bill just signed into law by Governor DeSantis has been thrown into the mix. It now requires the supervisor of elections to make a final determination of whether a person who has been convicted of a felony offense is eligible to register to vote, specifically whether he or she has paid off all court costs in their sentence before doing so.
I feel like if you've done the time for what you've done, you should not be punished to where you have no rights at all.
In response, civil rights organizations like the Florida ACLU have voiced their opposition. The ACLU announced it's suing the state over the new law, claiming it guts Amendment 4. The National Civil Rights Group is also speaking out, condemning what they call a, quote, modern-day voter suppression measure.
Adding extra steps, putting new barriers in the way, restricting Amendment 4, that is against the will of the voters.
The bill does provide a path for some felons to have their fines, fees, and restitution waived. If victims approve it, felons can petition a judge to either ignore those costs altogether or do community service hours instead. This law goes into effect on July 1st. First Coast News reached out to the governor's office for a comment Saturday morning. We're still waiting to hear back. Shelby Danielson, First Coast News, on your side.